I am here, and today we're talking about what to do if a tenant rejects your notice and what options you have as a landlord when you've sent out your notice, but that tenant has flat out rejected it. I've got a number of preset questions that I've received for those of you who join us through Facebook and contribute questions there or contribute through our newsletter. However it is you get your questions ahead of time, I've got questions here that I'm going to answer. But if you are unable to get your question in on time, then I strongly suggest that you add that to the chat here. For those of you who are joining and are out there and have a question that you weren't able to submit, maybe something pops up during the course of our live here, go ahead and add that to the chat. I'm happy to answer those questions. But today we're talking all about what to do if your tenant, hey James, good to see you. If your tenant rejects your notice, you can't just take it from the tenant when they say, nope, I don't care what you have to say. I'm not going to open it. I'm not going to even go near the mailbox. There's no way you're going to get your notice to me. So I'm going to give you 3 tips and 3 things to consider if you have sent notice that your tenant is simply rejecting. The first is, did you send it in accordance with the lease and with the law? Naturally, if you're sending a notice to your tenant, you're probably going to send it to the mailing address, but you may be issuing a notice, say a notice of default or a notice of non-renewal, to their email address. Well, does your state allow communication by email? In the state of Texas, Texas does, and many other states do. So that's an easy one. Does your lease allow it? I see a lot of landlords who say, no, I sent them notice. I sent them notice in writing. But then I asked them, well, what does your notice provision say is acceptable for purposes of notice? And their notice provision is blank, or they didn't include a notice provision in their lease. And so it's, oh no, I don't know. Well, the default is always by US mail or by personal delivery in the hand of the tenant. Some states will allow you to post a notice on a door, but that's not the best way to deliver notice, and it's not the way that we tend to advocate. For general notices that you're sending to your tenant, we suggest that you have reference in your lease to your notice provision. If your lease lacks a notice provision, you probably need to get a new lease. If you simply left it blank, well, you got to be on top of that as part of your onboarding process. Whenever you're signing a lease, fill out the notice provision so that when you do send a notice, you know that you're issuing it in accordance with your lease agreement. Because if you send notice and you didn't already agree that this was a viable method of notice delivery, a court could turn you around and say, sorry, bub, you didn't do it right. And because you didn't do it right, I'm not finding your notice acceptable for purposes of a legal procedure. If you want the law to work on your side, you got to operate within the bounds of the law. So make sure, is your notice sent in accordance with state law, and is it sent in accordance with the lease? If you check yes to both of those, then you can move on to the next, which is, can you prove that you sent or delivered it at all? And so with email, it's pretty easy because you can show, because of the date stamp and the time stamp on your email, that you delivered it and where it was delivered. The problem with email, and we see this from time to time, is the tenant who says, hey, I didn't get it. Maybe it went into the spam folder. Maybe it just got lost in the web of the internet. I don't know, but I never got it. And sometimes you're going to see tenants who make this claim, and sometimes a judge is going to buy it. Hopefully this doesn't happen often, but it can happen. And so what do you do to prevent that? Well, we always suggest that notices, particularly notices that you may at some point need to submit to a court, be sent through regular and certified mail. We send all of our notices this way. It's a tried and true method that courts, who still like things a bit old school, really, really like. It's been our experience in Texas courts that judges almost just accept it wholeheartedly. If you delivered it through the mail, it got there. If you sent it regular and certified, it got there. Especially if you got back a green card that confirms with a signature, or you got some report from USPS.com because you sent it through the U.S. Postal Service that the delivery is confirmed. All of this is great evidence that you can use to prove that you actually delivered it. Again, your email is usually pretty good about that, but occasionally you're going to have people who make certain claims that the courts find convincing, and email might not work in those situations. Because I've even had where a landlord personally delivered, put that notice in the hand of the tenant, and the tenant claimed in court, oh no, I never took that notice. You came up to me, I remember, but I put my hands up and I said, I would not take that notice. And the landlord insisted, no, I gave it to you, you took it. And she said, no, no, no. And what the judge explained was, she said, well, I find you both equally believable. She says no, you say yes. So I'm going to have to rule in favor of the tenant, because this was the landlord's case. And the landlord had to prove more likely than not that the thing happened. That's the burden in civil court, more likely than not. And we sometimes refer to it as 50% and a feather. So just slightly more than theirs. But if you're equal, if you're a perfect 50-50 split, you didn't meet your burden. And as the plaintiff, you lose on that point. And in this case, the plaintiff landlord couldn't prove more likely than not that he actually put the notice in her hand. However, if you've got a receipt showing the mail, showing what was mailed, and a concrete date, and if you've got proof of delivery through the report from the USPS or the little green card that comes from certified mail, that's always going to help. Again, also with email, if email is a viable option for you, it's going to have a lot of data on there showing data delivery. And again, 98% of the time, that's going to be excellent evidence as well, showing that you did, in fact, deliver it. But the last tip for you is, did you send it in multiples? So the first multiple is this something that's happened repeatedly? Maybe you have a violation that hasn't happened, that has nothing to do with rent. Maybe they're destroying the property. Maybe they're leaving the grass uncut. Maybe they have an unauthorized pet. And you've sent notice after notice after notice. Courts typically don't like single notices. But if you've got a multitude of notices, a multiple, and we tend to preach a 3 strikes and you're out policy here. If you've got multiple notices of stuff that you told the tenant to correct and the tenant refused to correct, that's usually pretty good evidence that they got to go, and it bolsters your position that they were notified. The same is true as if you send it in multiple ways. It's not good enough to just have one possible method of delivery in your notice provision. So let's say you are that landlord who always puts something in there. You want multiples in there. So yeah, you have the property address where you can send it by regular and certified mail, but you've got a man and a woman who signed the lease. You have his work email, his personal email. You have his phone number, and he agrees to accept texts there. You have her personal, her work email, her cell phone for text purposes, and you've got a tenant portal, and you also use some app that you use for communication. And so now you've got 10 methods of communication. If you utilize them all, it is highly unlikely that your tenant is going to say, oh, I never got that notice. They might try, but you've got 10 methods of notice. You've used them all, and you can demonstrate that to the court. So even if they reject any one of these, you've got evidence on your side showing, doesn't matter, they had more than adequate notice delivered to them. I can prove when I delivered it, and I can prove that it complies with state law and my lease. If you want to make sure your notice is rejection proof, these are the things that I recommend. Have multiple ways of sending it, send it in each of those ways, make sure you can prove delivery, and make sure it's in your lease and in line with state law. Let's see, I've got Red Dawn Radio with a couple of messages. I was forced out of my apartment of false false domestic violence allegations. I then found myself being forced out of my marital domicile. He goes on, I then realized I was left off the lease. The leasing office manager seemed to have a plan with my wife. I paid first, last, and security, and then I found out I've been purposely left off the lease. It happens. And unfortunately, it kind of seems like things happen in the worst possible scenario for you here. But if you don't have a copy of a signed lease or you don't recall signing a lease, yeah, it's possible that you get left off. And then when you're in a bind, it's impossible to enforce a lease that you're not a party to. And so unfortunately for tenants who find themselves in this position, I mean, you can only demonstrate to a court what was actually documented. So it's not in the lease. It's just not going to help you, whether you're the landlord or the tenant. What's in the lease controls. Despite what people may have intended, the black and white of the lease is ultimately what's gonna win the day. James E. writes, can a tenant install a video camera that records a shared parking area and back alley? Well, anything that's outside really isn't subject to privacy rights. So generally speaking, a landlord can set up cameras to surveil and protect their property. And you use the word install. Technically, and look at your lease, your lease may prohibit installation, like if they're attaching it to the house. But could they set up a camera that isn't otherwise installed for their own security or for their own curiosity? Anywhere outside, absolutely. There's no expectation of privacy outside the walls of the home. Red Dawn Radio says, thank you. You're welcome. I hope that's helpful. I know it's not super great news after the fact, but for future reference, I hope that's helpful. So now we've got our prepared questions from you guys. I hope those of you who submitted questions are here to hear these answers. This first one is from Eva and Benito Armas. And they asked this from our newsletter. How do I terminate a Houston Housing Authority lease that has since expired? There are no violations. There's no past due balance. Just want possession of the property. Well, so what you have here probably is a month-to-month tenancy that was created by your lease and by operation of just accepting the rent after the original lease term. So whether your lease has an automatic renewal provision or whether you just kept accepting rent after the fact, you've got a month-to-month lease. However, the original signed lease is still in effect. The only part of it that's different now is the term. Maybe it said from September 1st all the way to August 31st of the following year, but those months have come and gone. Everything else in the lease stays in place, including the rent, including the notice provision and all other provisions of that lease. So it's not necessarily that different that you've got an agreement with the Houston Housing Authority, except that when you send your notice of termination to the tenant, you also have to notify the housing authority. But how many days notice is required? That's going to depend on your lease. The lease probably has a provision in it that says this lease can be terminated, but requires X amount of notice. And so that termination generally doesn't even apply until you're at the end of the lease. But if you have a 45 or a 60-day notice provision required before that lease terminates, well, without termination, it lapses into a month-to-month. But you still have to honor that time limit so that if your lease says 60 days, you can give a notice, give the 60 days in accordance with the lease, then you can consider the lease terminated. However, the extra step for housing authority case is you also have to notify the housing authority so that they can make arrangements with the tenant in the event that they need a transfer voucher, which is very common in these cases. All right, let's see. James also says, thanks, you're very welcome. Muhammad Ali writes, can a tenant park a leaking unregistered car on the driveway? I don't know. What does your lease say about that? Generally speaking, a lease is going to prohibit the tenant from damaging the property, and an oil leak would definitely cause damage to the driveway. So, what does the lease say, and how can you enforce it? If you have a prohibition in your lease that limits a tenant from damaging the property or in any way altering the property, or that they have to properly maintain the property in a clean manner, then yeah, you're issuing notice to them about this default. Okay, yeah, leaking oil for sure. Uncle Cletus writes, how long after winning eviction does it normally take for the writ of possession to be enforced? Well, that's going to depend on your jurisdiction. And it's also going to depend on whether or not the tenant actually appeals. So a couple of things about a writ of possession. And now I'm speaking from a Texas perspective. I don't have insight on other states all around the country. I know that we get a number of people from out of state who watch. But as far as Texas is concerned, once your JP trial is over and you've won in the eviction court, the court's going to give no fewer than 5 days for that tenant to appeal. In certain instances, you're going to get additional time based on weekends and other factors, but generally speaking, about 5 days to file an appeal. And so, assuming the tenant files no appeal, you should thereafter be able to purchase the writ of possession. And in the Houston area, we tend to estimate the execution of the writ at about 2 to 3 weeks from the date of the purchase of the writ. So from judgment to execution, it could be anywhere from 3 to 4 weeks, assuming no appeal by the tenant. If there is an appeal, you can expect an extra 30 to 60 days before your next opportunity for a writ, and then you would wait the same. Well, it's actually a slightly longer period of time for a second appeal, but if they don't appeal the second time, and they shouldn't, but if they don't appeal the second time, you got to wait 10 days, and then you can get a writ, and then it's, again, the 2 to 3 week delay for service of the writ and ultimately execution of the writ. Now, I'll tell you that in most cases, the tenants leave within the first 30 to 45 days of an eviction filed here in the Houston area. For those who have to be forced out, who don't appeal, yeah, they tend to stay a little while longer, but very few actually wait for the constables to come in and forcibly remove them. I see that on very rare occasions. It's about 2% of cases, maybe less, of instances where the tenants don't just voluntarily move out. So most leave within 30 to 45 days. Those who take a little bit longer, it's probably another 30 days. And so those are pretty fair estimates, but the majority of them leave within the first 30 to 45 from the date of filing. James adds, Mohammed adds, even the lease stated no unregistered. Well, again, what you've got is a lease violation there, Mohammed. And so you have to issue a notice of default. And so I would say, for example, look, you're violating the lease for having an unregistered vehicle, and you're violating the lease for it staying in the driveway. You've got 3 days to move the vehicle and to remedy the stain. If they don't do it, issue another notice, issue another notice. If after 3 notices they still aren't doing it, I feel like you've got a pretty good claim for a default and termination. And so after 3, if they still don't do it, I'd issue a notice to vacate and then have them explain to the court why after notice, they still didn't correct this violation. So that's how I would suggest handling it. Multiple notices, giving them a reasonable amount of time to fix the thing. But if they don't, then a notice to vacate to get them out. James, a tenant is on month-to-month lease. Do I need to give a reason to terminate the lease provided I gave a 30-day notice? So in Texas, no, and in most states, you don't have to give a reason for termination. So long as you're not terminating on the basis of some, protected discriminatory practice, where you're not allowed to discriminate on that basis, you can have any reason. And so one pretty common one is that you're considering selling the property. And so if you feel like you have to give a generic reason if they ask, you can say that I'm considering the sale of the property. Now, whether you do or don't sell the property is of real no consequence, because we can always consider the sale of the property, even though you more strongly consider leasing to another party. If you want to give a simple diplomatic answer, that's one that I would suggest. But technically speaking, no, you're not required to give, nor are you limited to where there's some kind of fault on the part of the tenant, or because you absolutely need to move into the house. Certain states do require cause before you terminate, but not in the state of Texas, and not in many states. So, Uncle Cletus, I'm in Texas. They did not appeal. Thank you. You're welcome. I hope that helps. Again, the process is a little different, in different counties, but we like to kind of give a general idea of what can be expected in these scenarios. So I'm going to move on to the next printed question. Diane Simrad Eberhardt writes, I'm a small-time owner landlord of a rental duplex in which I fully manage myself here in Texas. I rent out both units, which are fully remodeled and very nice. I get conflicting information that since I rent out less than 4 units, that not all service or emotional support animal rules apply in this situation. I have severe animal hair allergies. Since I do the work on the units, can I exclude animals due to hardship to me? Also, when screening tenants, can I be more selective? I am over 60 and do not need any undue hardship. Absolutely, in your screening process, you can be as selective as you want, so long as you're not discriminating against individuals, against those protected classes, right? Race, religion, country of origin, that sort of thing. You don't want to do the illegal discrimination. Any other discrimination is perfectly acceptable. Which might mean, you have a higher standard for a credit score, or a higher standard for work history, or a higher standard for rental history, that sort of thing. Now, as far as the Fair Housing Act applying, this is the act where landlords are required to, allow for emotional support animals and service animals on the property. But there's a couple of things that you mentioned. Number one, let's say you had 5 to 10 units. Would you still be required to do this? If you can demonstrate to a court that it would be unduly burdensome to you because of your severe allergy for there to be pets on any of your 10 properties, it's possible that you can get by with this prohibition, because it would be extremely difficult on you to allow it. So that's possible. But now, since you have fewer than 4, you're right. The law does allow for an exclusion as long as you don't use a broker to list any of your properties. You can definitely do that, but I would lean more heavily on the issue having to do with your allergies, should you ever be challenged on this. So I don't know your medical condition, but if your allergies are such to a point where your doctor suggests that you should not have tenants who have pets, because that would severely affect your health, I would have something like that in writing, just in case you ever need to produce it. So let's see, Muhammad Ali. The lease stated that any unregistered car will be moved on the owner's expense. I don't know if that's enforceable. That's going to depend on your jurisdiction. If your county or your city, if that's part of their code, it's going to depend on a number of factors. Where's that car parked? If it's in a closed garage, it's going to be harder for the city to get a hold of it than if it's parked on the street or in the driveway. So that sounds like you're going to have an enforceability issue having to do with your jurisdiction, and I couldn't answer that for you. So let's move on. Anna E. Vitia writes, I'm trying to help a friend with a real estate property he has. He bought his first home years ago and moved out to be closer to home. He let his friend, problem, / coworker move in, and he was supposed to pay him directly the mortgage payments. Over the years, it was working, but last year it stopped. Sounds like you got a very easy non-payment of agreed rent But let's move on. He really never had a lease. Yes, he did. It was an agreement. You get to stay in exchange for paying the mortgage payment on my behalf. More like a verbal agreement. Well, Texas acknowledges verbal leases. Fast forward to now, he wants to just get rid of the home. Hasn't had any communication with a friend, but doesn't know the proper way since he knows he has to evict him first before being able to sell the home. He is avoiding having to go back and forth, and he would like to eliminate drama. Well, you got all sorts of drama cooked up in this one, I can guarantee you that. Would like to have some guidance. Who can he speak with or be able to do? Okay, so first off, if you don't want to have to do this, pass the torch. You hire an attorney, hire somebody who knows how to conduct an eviction and let them do it if you're not interested in doing it. But the basic steps are these. If you had an agreement, establish what the terms of that agreement were, and then hold your ex-friend to these terms. If the agreement, for example, was, hey, you were going to pay $1,200 a month while you were here, you did it for a while, but now you've gone a whole year without paying. Calculate what that turns out to be. If you've got $1,200 payable for 12 months, you've got about $14,400 in unpaid rent. I would send a notice to vacate on the basis of non-payment. And because the jurisdictional limit of the justice court in Texas is $20,000, you can even make a rightful demand for that. And I say, well, Ernie, look, I don't want the drama and I don't want to have to deal with that. You are better off 1,000% asking for unpaid rent in the situation, because non-payment of rent is the gold standard in eviction. And so you might want to do a less dramatic approach, but if your, again, former friend is self-aware and wants to prevent this eviction, they might just leave before you ever file, or they might leave before trial comes, and then you can just non-suit the case, dismiss it. Who cares once you've gotten possession back? Maybe you and he can work something out, but my suggestion would be charge him for the unpaid rent, send him a notice to vacate for non-payment, because you do have a lease. A lease exists. You exchanged X for Y, Y being the home, X being some amount of money that, again, the tenant was paying in the past. Rely on these terms, send the notice to vacate, and begin the eviction process. If you have too much difficulty doing that on your own, you're going to find it's going to be much easier just to hire somebody else to do it for you, so they take on the drama and not you. It's going to be faster, it's going to be more efficient, and it's going to get done right the first time. So that's my suggestion. Again, Mohammed, you say, according to the code enforcement, it's illegal to park unregistered cars in the driveway. That sounds like a police matter. And if you report that to the police and there's a procedure for having that car towed or having it removed, definitely you can enforce that. I don't know what the rules are in your jurisdiction. If you're asking me what I would do as the landlord in terms of the lease, it's notice, and then get him evicted. So again, so code enforcement is different. That's technically a criminal city matter and not necessarily a civil landlord-tenant matter. So number 4, Brandy Anderson writes, what can you do when a tenant appeals a supersedious bond? Now, I'm not super sure what you mean here, but it sounds like a supersedious bond was set and the tenant has appealed or said, Judge, this is way too high. There's no way I can pay it. Well, the court has all sorts of authority to alter its judgment in all sorts of ways. And I've seen courts lower supersedious bonds in the past. There's not a whole lot you can do. You can maybe petition, if this does go up on appeal to the Court of Appeals, you can maybe petition the Court of Appeals to raise it, but good luck with that. I doubt that's going to really make much difference. So what are we talking about in general? Well, your eviction starts off in the justice court and in Texas gets appealed up to the county court. That's one appeal. Your tenant actually gets a second appeal. And so if in county court they decide to appeal again, generally speaking, a supersedious bond is set. And we set those at 10 times the monthly rent. So if your rent is $1,000, if you plan to stay there, you got to come up with $10,000 within 10 days of this judgment. Now, during that time of the tenant appeals, the tenant can make their claim to the court. However, if they signed a lease or they agreed to pay this, then they're probably on the hook for the full amount. Even if they appeal with a pauper's affidavit, the rules don't change just because they want to stay and not pay the money. The court's probably not going to give them a handout, may lower the amount, but probably won't lower it to zero. So if the tenant is unable to pay the supersedeas bond, they probably won't be able to stay, because you're not going to be protected from the unpaid rent that inevitably will stem for multiple months while that case is on appeal. The reason they give the 10 months is they can presume at least 10 months will transpire between the appeal and the final order from the Court of Appeals. So follow through with the court. Make sure that if the supersedeas bond is lowered, that the tenant pays, and if they don't, get that writ of possession quickly. The appeal may move on, but once that writ of possession is executed, it's virtually a non-issue. Muhammad Ali chimes in, thanks. You're very welcome. Let's move on. Marcy Haas writes, thanks for providing this opportunity. My questions are really about the security deposit. I would like to know how a landlord can put value on the damages like a scratch or a dent on brand new stainless steel appliances. Also, if there is water damage on the walls, baseboard, and vanity cabinet in a small half bath with a small vanity due to carelessness, is the size of the vanity relevant? Can these be deducted from the security deposit? What if you see signs of water leaks on the ceiling that you were never informed of and are suspicious of a mold issue? Well, you've got multiple questions here. So let's talk first about assigning value to things like scratches and dents. One of the things that ultimately the court is going to be faced with is determining whether this scratch or this dent is from ordinary use or normal wear and tear. For example, if you've got furniture on a wood floor, you can expect just from normal use of sitting on a chair or sitting on a sofa over time, there are going to be some scratches on the floor. Now, there are ways to prevent that. You can put those little pads underneath the feet of the couch and underneath the feet of chairs, and that might help. But you can expect from time to time some scratches and some dents on certain things. And you were talking about appliances in particular. Are these normal? Couldn't tell you. I have no idea. The only one who can tell you, however, is the court. So the question for you is, does it make sense to show every scratch and dent to a court and say, Your Honor, I believe I was damaged by X amount? Probably not. The whole process of utilizing the courts to make these determinations is usually cost prohibitive, because you're not going to get a whole new refrigerator because of a small scratch or a little dent. You might get an award for diminished value. So if you have an $800 refrigerator and you've had it for 6 years, I can already tell you that just over the passage of time, that refrigerator has sunk in value. And so a dent on it might be $20, $30, depending on how large that dent is. I don't know that it's worth taking something like that to the court for a determination, because the court might say, a little more, a little less, but what did it cost to get there? So the thing that I recommend to landlords is the following. Look, figure out what you believe the resale value. Assume that you're going to sell this thing at a garage sale. If you're going to sell this thing, what would be the difference with the dent or without the dent? What would be the difference if you sold it at a garage sale after you used it? Now, maybe you've only had it for 1 year, maybe you've had it for 5 years, and that's going to make some difference in the sale price. But understand, you're not going to get the retail price to replace that machine, even with a dent in it. Right? So try to figure out as best you can, what's the value of this machine at this moment? And then how would that value have gone up if it didn't have this scratch or it didn't have this dent? I can, pretty well assure you that the price is not going to be that significant. You can tally these things up and take a nominal cost. In fact, you might want to determine a nominal cost for these kinds of things in your lease. So for example, you say, because you've had this problem come up, the appliances are free of any scratches or dents. Any scratches or dents may be determined to have a value of no less than $50 per incident, or something like that. You know, is that accurate for the appliances in your unit? Maybe it's something less, maybe it's something more, because you have, you know, higher dollar appliances. Unfortunately, all of these determinations, there's just no black and white rule for it. It has to be done on a case-by-case basis in front of the court. And so because of that, I would say, you know, it's a tough job to make these determinations. And you really have to ask yourself whether it's worth the trouble of asking in the first place. So a whole bunch of incidents, sure. Massive destruction to an appliance, yes. But small, you know, 2 or 3 things, I don't know that it's worth it to invite the trouble that might be caused from this kind of claim. Let's see, I know there was one other. Okay, so water from the ceiling is a different thing because it's probably caused from either a leak in your roof or from your AC. And it's hard to pin that on the tenant, even if they never reported it, because they might just say they never noticed it, or that it happened so quickly that they have no fault. And now you're left proving that. But you always have the right to come and inspect. And one of the things I always urge landlords to do when they inspect is to check that ceiling for this exact thing. Because over time, these kinds of incidents get worse. They never get better over time. It's always much, much worse later. So inspect with some kind of regularity and then go deal with it. You know, proving that the tenant is liable for stuff like that, it's a hard thing to do. And you can't just sit on your hands and expect the court to reward you because you didn't inspect the unit during the 3 years that the tenant was there. So keep that in mind. All right, let's move on. Sonia Mae Duncan writes, if a landlord has fewer than 4 units and wants to deny service or emotional support animals, can the landlord request that the ESA must be from a local doctor, psychiatrist, psychologist, and not from an online doctor? You cannot, well, number one, so it's fewer than 4 units. I guess the FHA doesn't technically apply unless by some other means it does apply. So I always tell landlords not to skirt around the rules, hoping that an exclusion applies. Just always follow the rules. As far as, you know, requiring that somebody get medical care from a specific source, that's probably not an enforceable term. So could you just say, you know what, I'm going to roll the dice and just not allow any ESA or any support animals at all? If you have fewer than 4 units, you can roll the dice with that and hope that the exclusion sticks. But I wouldn't go and make a rule, well, you can do it if you get your medical advice from, you know, some local guy here as opposed to online. Now, the online stuff, let's say somebody comes with that. If you can't confirm it, if it's not verifiable based on what's out online, you can deny it on that basis. And so I've had some occasions where people show up with documents they get from some online source, and the landlord goes and checks it out, calls the number, sends an email, is unable to confirm any of the data on that form. You can reject that. That's not something you were able to confirm, because anybody can produce a document and say, oh yeah, I got it online from my doctor. If you can confirm that this is a qualified health expert or a medical practitioner, then it's not a real document. And so no, you would not be obligated to accept that. James adds, these ESA animals seem to cause a lot of issues. I wish Texas would add some clarification. So the state of Texas does have some clarification through the Texas Workforce Commission. If you Google emotional support animals or Texas Workforce Commission and service animals, there's some guidance, but it's, you know, I mean, state law isn't going to trump federal law. And right now we're talking about the Fair Housing Act, which is a federal statute that we're all subject to. So, okay, so here is the very last question that we've got. Let's see. Koiyaka writes from our newsletter, I have a tenant that is smoking crack or meth on the porch of the property. They scream obscenities at 3 a.m. to 5 a.m., causing the neighbors to complain, and one sent me a video. I have since sent him an email notifying him that he is in breach of the lease and needs to vacate the property in 30 days. He has not confirmed receipt of email, and I'm not sure he will comply or not. Below is the language of the lease, and I've read the language, and yes, if he's smoking crack or smoking meth, he's definitely in violation. But I don't know what he's smoking, and I don't know that you can prove that he's smoking meth or crack. However, if he is causing a nuisance, and you do appear to have evidence that he's causing a nuisance, he is violating the lease. But, as I've mentioned before, I don't know that I would urge you to seek termination of the lease based on a single notice of violation. I recommend to landlords that you send a notice in writing, like we talked about before, in accordance with your lease and the law, and say, you've got a violation here. You must cease and desist, or you've got 3 days or 5 days or 7 days, something reasonable, to stop doing whatever you're doing. In this case, you're saying, I have evidence that I have a report that you were causing a nuisance on such and such date. Please do not repeat this behavior. So that one doesn't need a time limit. It's just a kind of a cease and desist notice. But he does it again, and you send another notice, and you say, look, if this behavior continues, I will be forced to issue a notice to vacate. This violates this provision of your lease. Please stop doing this. He does it one more time and say, look, I've warned you time after time after time. Unfortunately, this is it. You violated your lease for the third and final time. You are now being issued a notice to vacate. And so, again, like I mentioned before, I suggest that you have multiple mechanisms for delivering your notice, but also multiple violations. If you're going to issue a notice, it's going to result in termination of that lease. So I hope this has been helpful. For those of you who stuck around all the way to the end, I appreciate you. I want to let you know that I have a mediation scheduled for next Wednesday, so I won't be able to join you live, but I will be back in 2 weeks, and the topic is going to be the tenant refuses to pay their fees. And so I'm asking you, do you have tenants who won't pay their late fees, who won't pay repair costs or HOA fines? If you do, I want to hear all about it and the questions that pop up for you. Again, Wednesday, July 23rd at 4 p.m., I will be back. Let's see, James chimes in. I watched your recent video short on smells. Could you add more info, please? Not sure which one that was. I'll check it out. But yeah, smells are hard to prove. But non-payment of fees is easy to prove. And so if you've got a tenant who just isn't paying the full amount that they owe you, I want to talk about remedies for you. But until we meet that time, landlords, I wish you the best of luck. And until next time, happy leasing. You're welcome, James. I'll see you.